A parent has 3 children and names one of them as the primary beneficiary with the intent that they will divide everything evenly between themselves and their 2 siblings. And there were no instructions, just a conversation with that one child. And when the time came, because there were no written instructions, everything was unclear. The child that was the beneficiary was concerned about the tax consequences of receiving all of the assets and how things would get divided. And the 2 siblings sitting on the outside looking in were concerned and frustrated that they weren't part of the process. And what we found is that because of that lack of instruction and conversation, it created not a blessing of assets passing on to the next generation. It created concern and anguish and impacted the relationships of those children between themselves. And by no means was that the intent of the parent. And there was no ill will by any of the children in going through, but it was the nature of the process. Brene Brown, in her new book, Strong Ground, talks about the fact that clarity is kindness. I love that quote. And it's especially important for today's topic about the do's and don'ts of designating beneficiaries. Because the more clarity that we can have in our own planning will provide that blessing on to the next generation or those that will be receiving our assets. Now, today we'll be talking about a variety of different things that impact the beneficiaries, including tax and legal structures. Hammond Iles Wealth Advisors is an independent registered investment advisor. We don't provide tax or legal advice, but will be sharing some insights and encourage you to work with a professional in those areas who we also would be happy to partner with to make sure that your intentions are carried out. So one of the most important and powerful financial decisions you will ever make may be sitting on a form that you have not reviewed in years. When was the last time you checked over your beneficiaries? I would guess probably similar to maybe the last time that you reviewed your will or legal documents. It may be gathering dust in a drawer somewhere, or you may not even have a copy of your beneficiary forms. So that is an unknown question. And here's why this matters, because you can have a complete estate plan, you can have a thoughtful financial plan, you can even have well-structured investments and clear intentions that you've talked about with your family. But one outdated form can override all of your thoughtful planning and disrupt the process. So today we're going to talk about how beneficiary designations work, some of the common mistakes to avoid, the key planning decisions that you should implement, and a simple review framework that you can use to make sure everything's in alignment with your intentions. So what is a beneficiary designation? Well, it's a legally binding instruction that names a person, entity, or trust to receive your financial assets upon your death. And when we think about beneficiaries, here are some of the common accounts that we can use beneficiaries with. We normally think about retirement accounts like our IRAs, Roth IRAs, or employer retirement accounts like 401ks or 403bs. We also think about beneficiaries commonly with life insurance policies, but we may forget about the annuity or annuities that we have in place, and that there is an opportunity to name beneficiaries on non-retirement accounts. So if you have an investment account, you can actually add what's called a transfer on death or a TOD instruction to add beneficiaries. If you have at your bank, you can actually add what's called payable on death or a POD registration on your bank accounts. So any type of financial asset either naturally will have beneficiaries as part of the structure of that, or you can add it if you are aware of the fact that you can do so. Because when we pass away, there are three ways that our assets can transfer to the next generation or the people that we care about or nonprofit organizations that we want to impact. The first is through the beneficiary designation. The second is that you have hopefully a will in place. If not, that would be a high recommendation to put one in place. If not, then it goes into your estate and goes through the probate process. And it's called dying intestate if you don't have a will. And then basically the state laws and probate court will decide where your assets go. For some individuals, it may be beneficial to have a trust. And so those are the three primary ways to pass assets. And each one of them have a separate set of rules and different ways that they are treated. But today we're going to focus on number one, the beneficiary designation, although we will talk a little bit about how trusts and wills come into play, because many people forget the key rule that beneficiary designations supersede your will and other estate documents. You can have a very detailed will, have everything spelled out as to who you want it to go to. But the truth is any account that has a beneficiary designation will supersede this document. And so that's why it's all so important to make sure that you're reviewing your beneficiaries on a regular basis. Because when you align your intentions with your beneficiary designations, what ends up happening is in passing those assets on, it's very fast and efficient. It avoids going through the probate process. And because of that, it also is private. If it goes and is waited to go through the probate process with your will, that is potentially public information that can be obtained. And when your forms and designations are outdated, it can create delays. As the story I shared at the beginning, it can cause confusion and unintended consequences, whether that's tax consequences or in the story I shared about the consequences of just personal relationships between the next generation that's receiving your assets. We all don't want to leave a mess when we pass on. So here are some of the common beneficiary mistakes that we want to point out to help you avoid that problem. To start off, I want to talk about Anne and Bruce, a charming couple. They're happily married for 20 years. Anne is a former city school principal, and she died suddenly from a massive heart attack. And she had a pension from the school system that had a worth of over $900,000. And in looking at the statement, it didn't list a beneficiary anywhere. And Bruce just assumed, I'm her husband. Why wouldn't I receive her pension? Well, after she passed away, the officials went back in their files. And what they found was a document that was filed 27 years ago, well before she ever met Bruce, naming her mother, her uncle, and her sister as the beneficiaries of her pension. And so as a result of that document, they then turned to look at the mother, uncle, and sister, and Anne's mother and uncle predeceased her, but her sister was still living, and so her entire pension went to her sister. And because of not a great relationship with her sister, Bruce ended up with nothing. All because of one form. They may have had their wills in place, even a trust, but this document guaranteed that the money would go according to what she put in place 27 years ago. So the reality is that most beneficiary mistakes are not complex. It's just things that are simply overlooked. I'll get to that later, or I meant to update those forms, but I just haven't gotten around to it. So mistake one is not updating your beneficiary designations. So when we have major life changes like marriage or divorce or births or deaths, it's important that we revisit those documents and update them, because your forms will not update automatically. Just because you get married doesn't mean that your new spouse bumps to the front of the line on your designations. No, a new form needs to be filed to make that in place. So mistake number two is naming your estate as a beneficiary. Some people said, well, I have everything spelled out in my will, so I'm just going to leave it to my estate and let the attorneys and my family members take care of it. Well, what you don't realize is to get through the will and to all of the people that you care about, it has to go through the probate process, which is a lengthy process. If there's no will, it'll be allocated based on state law. And retirement accounts, which can trigger a tremendous amount of tax consequences, lose the opportunity to stretch those tax consequences out over a period of time. So we highly recommend against naming your estate as the beneficiary. Mistake number three is that there are no contingent beneficiaries. So when we take a look at naming beneficiaries on the account, you have yourself and you name your primary beneficiaries who will receive everything when you pass away. Now, there is a second layer of beneficiaries that can be named that are your contingent beneficiaries. So that if something happens to your primary beneficiary and they predecease you, now, just like mistake one, at that point, you would probably go in and update your beneficiary designation. But in the event that something happens and you don't update it, having that contingent beneficiary in place allows your assets to pass directly to the contingent beneficiary or beneficiaries if your primary beneficiary or beneficiaries passed away or predeceased you. But the problem is if you don't name a contingent beneficiary, then what ends up happening is just as if you didn't name anyone. Your assets may default to your estate or pass according to your state law, or if it's a retirement account, may go according to your custodian agreement. All those fun pages of disclosures with your retirement account that you may have skimmed over or didn't read, that might actually direct where your retirement account goes. Mistake number four, just like the family that I talked about at the beginning of today's webinar, is, well, they'll figure it out. I'll name one child to divide things fairly and allow them to handle their siblings and make sure everything is all set. But the truth is that there's no legal obligation to split those assets. And so potentially they could keep it all for themselves. As the family that I talked about, it created conflict between those siblings, being excluded versus having the burden of responsibility to divide things. And it can create unequal tax consequences. If it's a retirement account and you leave a sole single child as the beneficiary, they're going to have to incur the tax consequences to get that money out of the IRA to be able to then gift it and split it with their siblings. They don't have the ability of taking their inherited IRA and dividing it to their siblings without the designation on your beneficiaries. So it can create a lot of unequal tax consequences. Mistake number 5 is treating all assets the same. There are a variety of different assets and they're not all equal. Retirement accounts have distribution rules with tax consequences, and investment accounts or after-tax investments under current law may have a step up in basis depending on how they're owned. So they may avoid some tax consequences by the structure. So it's important to keep that in mind on how do we name beneficiaries, how do we want to leave certain assets to some beneficiaries and some to others. For example, if we want to include a charity in our planning, perhaps we leave the taxable retirement account to charity and then leave the after-tax investments that get the step up in basis to our family members or some mixture in between. It all needs to be taken into the equation of determining your intentions and how you want your assets to pass on to the people you care about. Now, number 6 is the lack of coordination. As I mentioned, there's a lot of different aspects. You have the beneficiary forms, you have your estate documents, you have tax planning on how you want it to pass tax efficiently, and you have your own intentions of what you want to happen at that point. All 4 of these should line up so that it is a clear lane of instruction as to how those assets should be passing. They should all align and work together rather than creating confusion of having a disagreement between different parts of your planning. So we want to make sure that everything is coordinated. So those are the major mistakes that people make. So how do we counteract that? How do we create clarity and kindness around our planning to make sure that our beneficiaries are designated properly? Well, first is we have to, I think, understand a little bit more about the types of beneficiaries. And I already talked a little bit about the primary beneficiaries and the contingent beneficiaries. So the contingent beneficiaries is kind of a second layer of beneficiaries that only receive assets if the primary beneficiaries are no longer living, but it's a backup. So if you're in the event all taking a family vacation together and for some reason have an accident where you all pass away, you have contingent beneficiaries named. Now, if you look back or look at a beneficiary form, you may see these other terms and may not understand exactly how that they work or the intent behind them. One is per stirpes and the other is per capita. And it is important to understand the details behind those so that you can make sure that the assets pass on the way that you intend them to be. So I'm going to share a few examples with you just to illustrate it. I personally find that it's easier to understand if I visually look at it. And so here is an example that you have an investment account of $150,000. And you've named your 3 children, child A, B, and C, very creative naming, to your beneficiaries. Now, at this point, child B and C don't have children of their own. Only child A has 2 children. Everybody loves the grandchildren. So we start to look at, well, how do we want our assets to pass if something happened to us? So example 1 is we're going to take a look at using per capita, which is equal among living beneficiaries. And again, I want to highlight living beneficiaries. So if we take the $150,000 and child A passes away, predeceases you, and the other 2 are living, per capita means that $150,000 is only going to be divided amongst the 2 living children. Now, again, hopefully, if you're working with a financial coach or someone like Hammond Iles Wealth Advisors, when that child passes away at that point, You would update your beneficiary designation and make a change. But if you left everything the same, per capita would result in the fact that the two grandchildren would basically be disinherited from this account because the assets are only divided amongst living beneficiaries. Now, if we take a look at the same example, but instead we name per stirpes, it's going to be equal with living children or branch of your family. So if we have the same scenario where child A predeceases you and child B and C are alive, under per stirpes, what generally happens is that child A's share ends up passing to the two grandchildren. So it remains divided three ways, but it follows the branch of the family. So child A's share passes on to child A1 and A2. So you'll see that that 50,000 got split evenly between the two living children. Now, if this flip-flopped, and let's just say that child C predeceased you, then it would get split two ways because child C does not have any descendants or any children for their share to pass on to. So that is something to keep in mind as well. Now, one of the things that is important to understand also is that is kind of the general terms on how per capita and per stirpes work. But when it comes down to the actual implementation, we need to take a step further and actually look at the underlying custodian's paperwork. So the investment company that you have your IRA or Roth IRA or your investment account with has their own rules on how they will treat and acknowledge your per stirpes or per capita designation for your beneficiaries. And I want to highlight this because for Hammond Iles Wealth Advisors, we primarily use Charles Schwab as our custodian for our investment accounts. And it's interesting that they operate a little bit differently. So for them, both per capita and per stirpes is going to work the same as long as one of the primary beneficiaries is living. So at Charles Schwab, even though child A predeceased you, the two grandchildren are still going to receive their share, whether you chose per capita or per stirpes. That's just the way Charles Schwab decided it, is that as long as a primary beneficiary is living, they're going to treat per capita and per stirpes the same. The only time it will be different is if all of the primary beneficiaries are deceased. And we'll go into an example on what that looks like. Just to add a little bit of nuance to the example, we're going to fast forward and child C now has three children of their own, just to show kind of how that works for Charles Schwab's difference between per capita and equal distribution amongst living beneficiaries. So in this case, again, at Charles Schwab, they're only going to look at the next generation if all of the primary beneficiaries are deceased. So we have child A having two children, child B had no kids, and child C had three children. So how does this all get split out? So under per capita, again, it's equal among living beneficiaries. So in this case, the $150,000 is going to be divided five ways, so all five grandchildren will get equal the same amount. $30,000 to each of them. So we took the account and divided it five ways. Now, if instead we check the box for per stirpes, it's going to be a little bit different. It's going to be equal distribution among living family members. So what ends up happening is that looking at the next generation, Child B, because he or she did not have any children, they lose that share. There's nobody to pass on to the next generation. So the remaining balance, or the 150,000, is going to be divided to the two children that do have descendants. So child A and their family will get 75,000, and child C and their family will get 75,000. So because there are two children of child A, they split the $75,000 evenly. So they each get $37,500. But for family C, because there are three grandchildren, they split the $75,000 evenly, resulting in $25,000 each. So you have to think about, do you want it even per family? And so you might choose per stirpes, or do you want it evenly amongst all grandchildren? And so you may choose per capita. So that's one of the other issues or things to think about as you're filling out a beneficiary form. Now, this is the way that Charles Schwab structures it and treats it. If you have accounts at Fidelity or Vanguard or any other investment company, you need to look at the way that they handle their beneficiaries, which most likely is different than Charles Schwab. Actually, I know that it is. So some beneficiary forms you can actually choose per capita or per stirpes per beneficiary. So if you have three children, you could actually designate which you want for each family and their inheritance to go. So it does add a little bit more complexity to it. And so we would recommend kind of sketching out kind of how your family tree looks like and how you may want your assets to pass on to those family members. Now, you may be saying to yourself, well, I didn't see anywhere on that chart for spouses. Sometimes there are concerns about spouses. Sometimes it's a second marriage for a child and you're concerned about spouse. Well, what about them? Well, spouses are not included in the beneficiary with per capita or per stirpes unless they are specifically named. So if child A, B, and C pass away, their spouses don't get anything under per capita per stirpes. It goes straight to the grandchildren. So the spouses are excluded unless you update your beneficiary form to include them. As I mentioned, those per capita and per stirpes applies to the descendants and not to the in-laws. Now, certainly when assets pass to your child, they pass to your child and not the spouse. However, just like when the assets pass to even the grandchildren, what happens next depends on your child's planning or your grandchild's planning. So the spouse may come back into the picture. If there's a divorce, for example, or something down the road, there may be an impact where those assets become available to a spouse or potentially. So that's something to consider as well. But keep in mind when we're creating a beneficiary form and naming per stirpes or per capita, spouses are excluded from that picture unless you specifically name them. Now, you may be asking, well, if I do have concerns about spouses, that might be why I have created a revocable living trust or created a trust document so that the assets stay in our family, especially if it may be a second marriage for you. You want it to stay each spouse's share into their own children and beneficiaries. It might make sense to have a trust. And a trust can help protect minors and provide some structure and control. But I want to highlight that naming a trust as a beneficiary, it adds a level of complexity for the administrative side of things. And I'll talk a little bit more about that. But it can help out with addressing some family issues that you want to plan around. But the biggest concern really around trusts and beneficiary designations goes around retirement accounts. I want to highlight that after the passing of the Secure Act in 2017, now most non-spouse beneficiaries, again, most non-spouse beneficiaries have to follow a 10-year rule where the requirements have to be, those retirement accounts have to be paid out within 10 years of inheriting them. And so there are tax implications. So when that money comes out of the retirement account, then it triggers the income tax. And as I mentioned earlier, that it adds some administrative complexity. So let me just share with you one example of where trust can provide a challenge in naming it as a trust. I have a client who created a trust that is going to ultimately benefit the grandchildren, but they do not want the grandchildren to receive any assets until they reach the age of 25. Now, hopefully, they'll be around long enough to see their children to 25 and beyond. But if something happened to them, then becomes the challenge if we name that trust as the beneficiary on a retirement account. Because the grandchild may be more than 10 years away from being age 25, but yet the IRA has to be distributed out within the 10-year time frame. So what ends up happening is that the account gets distributed out to the trust, and then the trust holds on to those assets until the kids turn 25 and then gets distributed out to the children. However, it's important to know that a trust, especially after you pass away and it's no longer your revocable trust using your social security number, it now has its own tax ID and becomes its own legal entity. The tax brackets for a trust are much smaller than for us as individual taxpayers. And so it does not take much in the way of income to be in the top tax bracket in a trust. And so if I have a large IRA and it has to pay out to my trust, it's being taxed to the trust because it's not being paid out to the grandchildren yet. So it's incurring a higher level of income tax on that process. So when we think about naming a trust, we have to take these new distribution rules into consideration. And what this client ultimately decided is that they're going to name the grandchildren directly as beneficiaries without naming the trust so that they can stretch it and recognize the tax consequences as it comes out. Now, certainly, yes, could they take it out faster and spend it? But at that point, it'd be hard to control it. So it's a balance between, do you want the control or do you want the tax savings? Is it really worth having the control if you're going to lose over 40% of the retirement account to taxes because it's taxed at the trust level? That's a decision for you to make, but it is a layer of complexity that we don't really recommend when it comes to retirement accounts. As I mentioned, for non-spouse beneficiaries, they must be distributed within 10 years. And this is something to consider even for you naming beneficiaries in your planning. So how do you go about doing some planning around your beneficiaries? Do you do Roth IRA conversions to reduce the tax consequences to your beneficiaries? What are some other planning that you can do? And we have other webinars that you can find that talk about reducing your required minimum distributions and some of the planning strategies that you can implement around that. Now, one of the planning strategies, you can actually name a charitable beneficiary. So you can make a thoughtful strategy that supports a cause you care about and potentially eliminates income tax since the charity inherits it tax-free as a nonprofit organization, and it can align your wealth with your purpose. One thing I would highlight here is that charitable beneficiaries, we talked about non-spouse beneficiaries having 10 years to take out retirement accounts. Charitable beneficiaries have to take it out within 5 years, although they probably won't wait 5 years because it comes out tax-free. However, if you name charity and children on the same account, it's all going to default to the beneficiary with the shortest time frame. So if you do want to include charity in your planning, I encourage you to split the account so that you have a separate account just for charitable beneficiaries and then a separate account for your family members that are living, breathing individuals that are going to inherit. So you want to break those apart if you do include charitable organizations. Now, as an example of this, I just want to show you the power of planning when it comes to beneficiary designations. And one of the strategies that I love is what I call double the impact of your retirement savings. So I want to introduce you to Arthur and Michelle. Arthur has $1 million IRA, and although I'm using $1 million just for a round number, this strategy can work for any size IRA, what you use. And both Arthur and Michelle are both 73 years young. So that means that they now need to start taking required minimum distributions. And thanks to a pension and Social Security, they have plenty of income. So they don't need the required minimum distributions for retirement income. And when we talked about what their intention was and what they wanted to accomplish, they said, I want to leave a legacy gift to my family. I want to pay as little in income taxes for themselves as well as their children. And they wanted to create an impact on their favorite charities. So we took a look at doubling the impact. So when we take a look at $1 million retirement account at age 73, Arthur will be required to take a minimum distribution of $37,736. Now, certainly with 22% federal tax and here in Connecticut, 4.6%, he's going to pay $10,000, a little more than that in income taxes. And what we're going to use the bulk of the remainder of that is we purchased a second to die life insurance policy. And we set the death benefit at $1 million, basically the same level as the retirement account. And it's second to die, meaning that it's based on 2 life expectancies, so the cost of the premium is lower, but the death benefit doesn't pay until the death of the second spouse. And even taking that premium off, they still had a little bit left over that they could spend however they like. Now, keep in mind 2 things. One is that life insurance proceeds are income tax free. So if we set up $1 million second to die life insurance policy, their family members will receive those proceeds 100% income tax free. Also, the premium on that permanent life insurance policy is fixed. So even though the required minimum distribution will increase every year as they get older and the size of their retirement account hopefully grows, the annual premium remains the same. So the leftover portion, which they can spoil the grandkids or take an extra trip, will get bigger over time. Now, when we take a look at the $1 million in the retirement account, now if we name children as the beneficiary of that, they're not going to get $1 million because they have to pay the income tax on the way out. So when you're looking at a retirement account, it's not all yours. Uncle Sam is standing there with his hand out saying, you need to pay the toll on the way out to pay the taxes. And so what we did in this case is certainly we want to make sure that Michelle is taken care of. So during her lifetime, she's the primary beneficiary. So if Arthur predeceases Michelle, Michelle will inherit the retirement account and continue this process on just as if Arthur were still there. However, they named their favorite charities as contingent beneficiaries. So when both of them pass away, the entire retirement account will pass on and make an impact to the charities they care about. And because it's going to nonprofits, they'll receive 100% of the retirement account tax-free. So if we make the assumption that the retirement account just grows enough to keep up with the required minimum distributions, it's still going to be $1 million left. So they're going to leave $1 million tax-free to the charities that they care about. On the other side, they have a life insurance policy, a second to die policy that has $1 million death benefit that passes tax-free to the kids. So what have we accomplished? We took $1 million account and we've created $2 million of impact with no income taxes. We've now disinherited Uncle Sam. So now charity is getting the full retirement account and the kids are getting the full death benefit. We've now created double the impact of the retirement savings. So you can see how implementing some strategies around beneficiaries can create a bigger impact, not only with your family and the people you care about, but also with the organizations that you care for. So we've talked about the challenges that we face, the mistakes that get made commonly, and we talked about some planning and strategy and things that we need to think about in designating our beneficiaries. So now it's time to take action, and we've put together a review checklist for you of things that you need to check the box. And if you'd like us to provide you a print copy of this, we'll be happy to do so. Just send an email to hello@hiwealth.com. The first is review all of your investments, retirement accounts, and insurance policies. So everything that has a beneficiary or could potentially have a beneficiary should be reviewed to make sure that it's set up properly. If you work with Hammond Iles, we're happy to review any account that you have, whether it's through us or outside of our firm. And if you're not working with Hammond Iles, we'll be happy to review your beneficiary designations with you. It's important to confirm not only the primary, but also the contingent beneficiaries are named. And it's important to confirm it because just because you sent in a change of beneficiary form does not necessarily mean that the company processed it correctly. It's important that you have a written letter or notification of the current beneficiaries or contact those companies to confirm what they're showing in their records. It's one of the things that we always follow up on now is we make sure any form submitted that it gets properly processed. And then if there are any major life events that happen, whether it's a death, a marriage, a birth of new children or grandchildren, it's important to update those designations. You also want to ensure that your choices reflect your current wishes and the family dynamics. So again, do you use per serpes or per capita on how you want that to pass on to the next generation? You want to evaluate, does it make sense to have a trust or a charitable beneficiary as part of your beneficiary designations? You also want to review your retirement account, not only for looking at the beneficiaries, but also the tax consequences and implications of naming those individuals as a beneficiary on those retirement accounts. And you want to make sure that the beneficiary designations confirm the alignment with your overall financial plan. You want to make updates and make sure you keep records of the changes. Part of the Hammond Iles Personal Financial Portal is that there is a vault that you can store digital copies of documents. It's a great place that you could scan and upload and keep all of your beneficiary designation forms in one central location, easy to access by you or your children or beneficiaries. And another thing that we've started offering over the last few years is hosting a family meeting. Just like the family I started talking about, one of the problems is that the parent only had a conversation with the one child that they were naming as the beneficiary, rather than calling all three children together for a family meeting and saying, hey, I am structuring my beneficiaries where this child is being named as the sole beneficiary just because I want them to allocate it out to you as best under the current law at that time. Then the children will understand and you can prevent some of the damage that can happen in relationships. So consider hosting a family meeting, whether that's in person or virtually through Zoom. And we'd be happy to host that meeting for you to not only review your beneficiaries, but talk about the overall financial plan. So bringing it all together, thoughtful planning is not just about building wealth. It's also about making sure your assets are transferred in a way that reflects your values and supports the people you care about. Don't let the last thing people think about you is they left a mess that is taking time and energy and emotion to deal with, not only grieving your loss, but then they have to deal with challenges afterward on getting everything organized. Help them out. Make sure you plan appropriately. Because again, this isn't about complexity. I mean, we certainly did talk about a strategy that involves a few different moving pieces, but in general, naming and designating beneficiaries is not a complex process. It's one of the few things you can do with just a single form without an attorney involvement. It's very simple, but it's about coordination and making sure that it all works together. Because small adjustments today can help reduce confusion, improve efficiency, and the speed at which those assets get distributed out to your loved ones, and it protects your intentions. So the key takeaway that I hope you realize is that beneficiary designations are not just paperwork. They are your personal instructions to be carried out. And so they're worthy of taking the time to really look, review, and update them. So your next steps is do not assume that your designations are current or correct. Don't make that assumption. You know what they say about assuming things. Take time to review them, and we are here to help with that process. So if we can be helpful in sitting down and reviewing your beneficiaries with you, please reach out to us. We'll be happy to help. And if you are not currently a client of Hammond Iles or you're watching this video on our YouTube channel, please know that we offer a free conversation with a financial coach. So we'll be happy to assist you on reviewing your beneficiaries. You can go to our website at hiwealth.com to schedule that conversation or scan the QR code on the screen at this time. It's time to schedule a beneficiary review. If you haven't, contact our office and schedule a meeting to review your beneficiaries. It may also be time to host a family. If you have everything in place the way you want it, it's time to bring the family together to have a conversation on why you're structuring it the way you are. Why are you deciding to leave part of it to charity, or why are you not doing that, or why are you structuring it where some are getting after-tax investments versus retirement accounts, and how is that all structured? It's time to communicate and have a conversation around that. It also introduces our firm or your financial advisor to your family, so when you're no longer around, they have someone to turn to guide them through the process. If you found this webinar helpful or you'd like to watch it again, you can view the recording on our YouTube channel as well as some of our others that talk about different types of beneficiaries for retirement accounts, as well as strategies to reduce required minimum distributions or strategies to use if you don't need your required minimum distributions. They're all there on our YouTube channel. Just go to youtube.com and search Hammond Iles. Also, you can get additional information by following, connecting, or like us on social media, as well as going to our website where we have additional resources available to you. So I'd like to just thank you for taking time to be with us today. If there are questions that you have about your personal situation, please reach out to our office or send us an email at hello@hiwealth.com. We're here to help.